Okay, this is the last part of the Bill of Rights lecture unit, and I want to start with a case, Duncan v. Louisiana. In October 1966, Gary Duncan, a 19-year-old African-American, was driving down a Louisiana highway when he noticed his two cousins with a group of white youths on the side of the road. He became concerned because his cousins had reported occurrences of racial incidents at the recently desegregated school. He pulled over the car, stepped out, and asked his cousins to get in the car. The white youths testified that Duncan slapped one of them at this point, while Duncan and his cousins denied it. Duncan was arrested and ultimately charged with simple battery. As it is punishable by no more than 2 years, simple battery is a misdemeanor under Louisiana law and therefore not subject to trial by jury. Duncan was convicted and received a 60-day prison sentence and a fine of $150. He appealed on the grounds that the state had violated the 6th and 14th Amendments, guaranteeing his right to a jury trial. What do you think? Should he have a jury trial, and why? So I'll skip to the point. Justice White noted that the right to a jury trial for criminal offenses is a deeply enshrined value in both British and American legal traditions. Despite its particular flaws, he said its importance was widely recognized and meets the test of being deeply rooted in this nation's history and tradition. Thus, a right to a jury trial in criminal cases is within the 14th Amendment and therefore is applicable to the states. And number two, the question for the court was whether an offense subject to 2 years imprisonment is a serious offense. The majority noted that at the time of ratification, crimes were punishable by no more than 6 months imprisonment and were typically subject to jury trial. Furthermore, both federal and 49 states recognized that a crime carrying a sentence of over 1 year necessitated a jury trial. The court found that Louisiana law was out of sync with both the historical and current standards of the justice system and was therefore ruled unconstitutional. Okay, next slide. Change of venue. The Sixth Amendment also guarantees the right to change of venue. Due to the family's expense of traveling to different locations, Florida in 1994 passed a law allowing for a jury to be chosen in one county and a trial heard in another. This covers the right to an impartial jury. For example, if the defense can show that a specific jury pool is likely to be biased, the court can order a change of venue. The Sixth also covers the right to a public trial. Okay. This doesn't mean that anyone can attend. If the right to a public trial is outweighed by a compelling state interest, the trial may be closed, but the side seeking to close the trial must show in advance an overriding interest that allows the public. It may prejudice the trial. In addition, some parts of the trial may be closed, such as when the identity of an undercover informant testifies. The next right guaranteed by the Sixth is the right to be informed of the nature and cause of the accusation. The reason for this right is to prevent the practice, common in some countries, of holding suspects indefinitely without telling them why they are being held. The Sixth also confers the right to confront opposing witnesses. The only time when this is not allowed is when the suspect causes such a ruckus, even after being warned, he or she can be removed. In about 30 states, potentially disruptive defendants may have a stun belt strapped to their waist instead of being shackled. If they become violent or try to escape, a deputy can push a remote control button that will deliver an 8-second charge of 50,000 volts and 4 milliamps of electricity to the defendant's kidneys. That doesn't sound very good. The jolt of electricity will likely knock them to the floor, incapacitate them, and cause them to writhe in pain. They may also lose bladder and bowel control. Apparently, just the threat is enough to keep defendants in line. Nationally, between 1991 and 2002, the belt was strapped on 62,000 defendants and only activated 34 times. The offender also has the right to require a favorable witness to testify. This is the right to subpoena witnesses. This amendment is extended to cover the states in 1967. And finally, the right to counsel was extended to states in 1954. And the next case that we'll talk about is Powell v. Alabama. March 1931, 9 African Americans were accused of raping 2 white women, Robbie Bates and Victoria Price. The group was traveling in a freight train with 7 white males. They got into a fight, and all but one of the white males was thrown off the train. The woman accused the black men of rape. One woman later retracted her claim. All but one man was sentenced to death in a series of one-day trials. The defendants were only given access to their lawyers immediately prior to trial. The ruling was appealed on the grounds that the group was not provided adequate legal counsel. The Alabama Supreme Court ruled 6-1 that the trial was fair. The ruling was then appealed to the U.S. Supreme Court. What do you think was the outcome? Remember, this was 1931, roughly 30 years between the 60s and civil rights marches and demonstrations. This was the first time the court had reversed a state criminal conviction for a violation of a criminal procedural provision of the Bill of Rights. Prior reversals had to do with racial segregation in jury selection, which violated the Equal Protection Clause. The court held that due process had been violated based on 3 arguments. The defendants were not given a fair, impartial, deliberate trial. They were denied the right of counsel with the accustomed incidents of consultation and opportunity for trial. And they were tried before juries from which qualified members of their own race were systematically excused. There was much debate over whether the decision applied to non-capital cases. In Betts v. Brady, it was decided that unless the defendant was illiterate, stupid, or it was a especially complicated trial, there was no need for a court-appointed attorney. The decision was ultimately overturned in Gideon v. Wainwright, which established the right to be provided an attorney in all felony cases. The 6th also extends the right to an effective counsel. In 1984, the court set the standard for effective counsel. The counsel's performance was not reasonably competent or was below the standard commonly expected. 2, that the deficiencies in the attorney's performance were prejudicial to the defense, meaning that the results would have been different if the attorney had been competent. The 6th also gives individuals the right to refuse counsel. This amendment has not been extended to the states. The 8th doesn't say that bail must be granted, but it must not be excessive. Excessive bail is determined by nature and circumstances of the offense, weight of evidence against the suspect, character of the suspect's ties to the community, the ability of the suspect to pay bail. Finally, the 8 accords protection against cruel and unusual punishment. This amendment was extended to the states in 1962. Generally, this amendment is discussed in terms of the death penalty. For about 120 years after the adoption of the Bill of Rights, the Supreme Court interpreted cruel and unusual as only the most barbaric punishments and tortures. The court in Wilkerson v. Utah, 1878, provided examples of punishments that were prohibited. These included the criminal being emboweled alive, beheaded, or quartered. Later, they added punishments that involved torture or lingering death, such as burning at the stake, crucifixion, breaking on the wheel, or similar punishments. Nobody should commit crimes if those were the punishments, huh? The way this stands now is that a punishment is not considered cruel, unusual, as long as it's not grossly disproportionate to the magnitude of the crime, it's been imposed for the same offense in other jurisdictions, and it's been imposed for other offenses in the same jurisdiction. And I want to end with miscarriages of justice. Even though we have the procedural rights we've discussed to protect innocent people from being arrested, charged, convicted, or punished for crimes they did not commit, it's one of the most highly developed systems of due process rights in the world, and people continue to be victims of miscarriages of justice. Barry Scheck and colleagues report that in the first 18,000 results of DNA tests at the FBI and other crime laboratories, at least 5,000 prime suspects were excluded before their cases were tried. It's impossible to determine how many false convictions occur every year. However, there was a survey of legal professionals that concluded that a conservative estimate of all felony convictions was that approximately 0.5% were in error. The authors of this study believe that the frequency of error is probably higher in less serious felony and misdemeanor cases. This may not seem like a lot, but when you consider that approximately 14 million people were arrested in 2009, and maybe half were convicted, making it 7 million, this means that 35,000 people were probably wrongfully convicted. And that ends my lecture on the Bill of Rights.